Move on now, and let's deal with the issue of the justices of both the Superior Court and the lower courts here in Ghana, 34 in all, who have been indicted in some, corruption or bribery scandal here in this country. And I'm thankful that we are also being joined right now by a man that not too long ago you saw parts of a reply to the Chief Justice Committee for his clients being leaked in the media about the fact that his clients in the circumstances had actually not touched any money whatsoever. If you watch the videos, you won't see him do any of that thing. And the person who he's alleged to have freed is actually in custody. So what was the point really? And they are really, really very angry about some of the processes that are going on now. Gary Nimako Mafo, good morning. Thank you for joining us.
Samson. How are
Great.
you?
I'm very good, sir.
Good.
And on the line is Captain Nkrabia Efa that retired. He's also a lawyer for one of the judges. Thank you. I understand you're on the line right now. Good morning and welcome to the show, sir.
Thank you very much.
Great. Well, we know that you already have taken issues with the police proceeding to invite your clients to seek to investigate them for the purposes of prosecution. What exactly is your problem with that?
Well, thank you very much and good morning, Newsfile, and to your listeners all over the world. The issue is simple. According to the Constitution of Ghana, 1992, judges of the Superior Courts are not like the ordinary citizens of this country. When a justice of a Superior Court is alleged to have misconducted himself, the Constitution lays down a specific procedure which has to be followed in dealing with him. And this is laid out in Article 146 of the Constitution. Now, the procedure is for a petition to be made and referred to the Chief Justice, who will look at the petition, the substance of it, and then in his capacity as Chief Justice, take a decision that there is a prima facie case made against the justice, so that a committee set up by the Constitution is put in place by the Chief Justice, specifically to listen to look at the petition in camera and then take a decision as to whether or not the judge is convicted, or shall I say that the judge is...
Okay. Hello?
Whether the judge should return to work or should be dismissed from the judiciary. Now, it is after the committee set up by the Constitution had finished its work that a decision will be taken as to whether criminal proceedings should flow from it or whether the matter should be put to rest. Against this background, it is premature and it is too early for the police to open a docket on the Superior Court judge and start investigations with a caution statement and so on and so on. So we put this in writing to the Attorney General, Chief Justice, IGP, and complained that they should await the proceedings or the decision of the constitutionally mandated committee, which has been set up by the Chief Justice. So that is my beef or my problem with the police network.
Okay.
I must say, though,
yes,
that yesterday when we appeared before police, we made them aware of this, our position. We had a letter, and the lawyers, the committee is made up of police officers, most of whom are lawyers. They understood the point we were making, and it's to suspend the sitting until they hear from the Attorney General. So that is where we are.
Did I hear you say that the police have decided to suspend this process until the CJ's process is over?
No, what I said was that the police that we met yesterday, they have told us that because of the content of our letter, they are suspending sittings with our clients until they hear from the Attorney General, who directed them to do that.
Because they seem to agree, they agree with you that the two processes cannot go on side by side?
Well, they did not say they did not tell us their opinion. All they said was that we have brought a letter, so they are going to await the decision of the Attorney General on our letter.
And what is the basis, legal basis of your position that the two processes cannot go on side by side or simultaneously?
Yes, the two processes cannot go on side by side. The Constitution is very clear. When a judge of the Superior Court is accused of a misbehavior, the process is for the Chief Justice to determine whether there is a prima facie case against the person. And then proceedings are held in camera to determine whether or not there is meat in the petition, or whether the judge...
Can you help us understand? Can you help us understand? Is there any difference between the constitutional provision over being investigated for stated misbehavior or misconduct and crime? Are there any difference?
Yes, there's a big difference, because you see, when it comes to the constitutional provision regarding the stated misbehavior of a Superior Court judge, the idea is that because of the independence of the judiciary, the Constitution says clearly that a judge is inviolate, he is indemnified, if no action can commence against him in the performance of his duties. This is calculated to protect the judiciary from interference from left, right, center. And that is why the procedure has been put in place, that when a judge of a superior is involved in a misbehavior, a special process is put in place. And after the conclusion of that procedure, the decision would be, yes, the person has misconducted himself, so he should be dismissed from the service. And then he will be reduced to an ordinary person. And then when he gets into that level of we, the ordinary people, then the police can then investigate, take statements, compile a docket, and push him before a court for trial.
Oh, but I thought I just heard you say that the Constitution indemnifies the judges from any prosecution for omissions and commissions that may occur in the performance of their duties. I just thought I heard you say that.
When you have a problem with a judge, you write a petition, and the Chief Justice will determine whether there is merit in your petition.
Yes, that point is noted.
Hello? Are you with me?
That point is noted. But you mentioned also that the Constitution is clear that you cannot prosecute them, so to speak.
You cannot prosecute the person until a prima facie case has been established and acted upon by a committee set up by the Constitution itself. So, please, I want you to get the sequence right. A judge commits, whilst a person is a justice of the Superior Court, no action can be brought against him in the performance of his duties. Now, in the performance of his duties, he misconducts himself, but he is protected by the Constitution. So the same Constitution says that because of an allegation of misconduct, he should be brought before the Chief Justice, who will look at the petition and decide that there's prima facie. And then whether or not that allegation is solid will be determined by a committee that sits in camera.
Okay.
All this go on without the public's knowledge.
Okay.
So the committee
we have heard. Sorry, but we have heard enough. We have heard enough about this committee's process. But you have labeled the current attempt to prosecute as well as a case of double jeopardy, and that is why that is what the Constitution frowns on. That's the essence of your point, isn't it?
No, that is not the essence of my point. The essence of my point is that a justice of a superior court is not an ordinary person. So, before the police can seize him, arrest him, and grant him bail and take statements of him and determine whether or not to prosecute him, that was begin. That's constitutional proof set up by the Chief Justice to the prima facie case made against him has completed its work. That is what I'm saying.
Okay.
That is the constitutional procedure. And unless that is done, the police will be acting prematurely. It is too early for the police to act. Where a justice of a superior court is concerned, mark my words, I'm not talking about magistrates. I'm not talking about circuit court judges.
Okay.
I'm talking about superior court judges.
Right.
Article 127, Article 146 come into focus.
Yes. How do you explain to Ghanaians who are asking themselves the question, what then becomes of the meaning of Article 17(1), which says all persons shall be equal before the law?
It is the same constitution which says that justices of the superior court, their actions are invalid, and you cannot bring an action against a high court judge in the performance of his duties. Their actions,
including actions that border on criminality, including actions that border on criminality. They have immunity.
The words in Article 126 are clear. Any action. It didn't say some action. Any action. And please, don't forget that the bedrock of our democratic system...
Sorry, let's clear this briefly. You refer to Article 120 what?
127.
127(3), right?
Yes.
Okay, kindly hold on. I want to read it so that we can all follow. Article 1273 says that a justice of a superior court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. That's what you mean?
Yes.
Okay. I've seen a video and I've seen a judge taking money, taking goats. Is that the exercise of judicial power?
Well, the action of a judge taking a goat or the action of a judge receiving money is not exercising judicial power, no. But the person is a judge, and any act of his at any particular time can be represented either way. Now,
Captain retired in Krabia Fadate on the line speaking to us about the problems that they have with the current process. Unfortunately, we seem to have lost him on the line there. We seem to have lost him, but we'll try and then continue the discussion here with Gary Nimako, who is also in this whole case. Thank you very much once again. Do you share the views that Nkrabea Fadate canvasses? And I've heard John Indebugri, also lead counsel for 14 of the lower court judges, canvass the same point, particularly in reference to Regulation 30 of the Judicial Service Act, which says that, which says to the effect that, whilst the process is going on to, as it were, what is going on now, you cannot at the same time go ahead with criminal prosecution until one process is over.
Well, Samson, let me say good morning to your cherished viewers this morning, and then good morning to my senior brother Kokubako and my brother Kokukwati, and yourself. Samson, in all this, the question I ask myself all the time is, why the haste? Why the haste? Where are we rushing to? There appear to be a certain semblance of we have to do something in a manner which we say expeditious manner. And if you are not careful, you will end up trampling upon the rights of these judges. Now, I have been monitoring.
You said there's a hasty, the process is hasty.
Exactly. Let me something, but you can see. Let me tell you why I say it's hasty. Look, I now submit a petition to the president and it's given to the Judicial Council. In less than 3 days or so, the contents are published in the media with pictures of judges all over the place.
The contents of the petition?
Oh.
I'm yet to cite one in the media.
Well, you let us not go there. Now, the likes of my senior brother, Mr. Bako, and Anas himself, they are all over pontificating as if the contents of the video footage is sacrosanct. It's unimpeachable. And therefore, everybody should just agree that once the video has been captured, without cross-examination, without more, we should all accept that as evidence of bribery and corruption. I think that we should be very careful here, because you see, even armed robbers who are caught at gunpoint or who are caught red-handed robbing people are given all the constitutional latitude and protection to defend themselves or by a lawyer. And then, having gone to the full mail of the trial, then they are punished according to the law. This is not to say that, look, anybody, if it is so that a judge or whatever has been found to be corrupted, for some other reason we shouldn't punish the person. But the haste.
The ordinary Ghanaian wants to understand what you mean by haste, because some of them have been accused of one thing in the morning and by afternoon they've been convicted.
Mr. Ladi, you know something? It is not for any reason that the Constitution laid down procedures to deal with judges. It's not for any reason. That the Constitution itself, which will regulate our lives, our way as a nation, laid down procedures that if you want a judge to be removed, these are the constitutional benchmarks to be followed. Now, if for some reason person A or person X or whatever submit a petition to a body like a judicial body, President, Judicial Council, to look into it, and then a committee set up to investigate and look into the matter, before they could even say, Jack, the videos are floating all over the place and they are being aired all over the place. But the question I ask myself, having shown the video, what happens next? Having shown the content of the video to the public, what happens next? Now, we sit in this country, and I can tell on authority that this video has been given to Al Jazeera. The video has been given to Al Jazeera. And they called me, and I declined interview. They called me, and they say, I do not understand the haste with which these things are going on. If Anas Aremia or Anas, in fact and indeed, wants the Chief Justice and the committee to do their work, why the haste? If I were him, all I would do is that after petition is submitted to the authorities, I will sit back quietly and watch them do their constitutional mandated work. And if the committee finds out that the judge has indeed collected money to influence him in the education of a matter, the committee will apply sanction and punish the judge.
Well, he'll tell you that this is a journalistic work and it is meant for publication. But,
no,
I'm not inviting a debate on that. What I want to know now is that. What I want to know now is.
Wait. Let me make this point.
How exactly do your clients want this process to proceed?
You see,
that you finish with this first.
The point that all of us must understand is that a judge is a human being as me and you are. The Constitution gives us all about the protection and the latitude that they all deserve, that they must have. I think that is a proper that we should all take our time. We should all take our time. Because like I've always been saying, that you see, if for some reason the person has done the wrong thing, look, even if it takes 10 years, he has done the wrong thing, and he will be punished appropriately. But if you are not careful and then we rush a process, and every day the media is on this matter, and I've been monitoring the media landscape until now, we're monitoring it. If you are not careful, we're going to have a lot of problems. Now, if we bastardize our judicial system, which is the last place for all of us to go to have our grievances vindicated, and we destroy it. Now people have destroyed the executive, parliament, they are destroying it. Even now we come and destroy the judiciary. If Kokubaku and the rest they get problem, where would they go?
You mean exposing corruption is destroying the institution?
I am not saying exposing corruption destroying judiciary. That's what the Constitution said. Proceedings, everything that you submit your petition, it should be done in camera. There's a good reason for that. It's a good reason for that. It's a good reason why
you object. You object to the invitation presently being sent to them to appear before the police for investigations for prosecution.
Oh, I think that, you see, we should pace ourselves and take our time. That's the way I think we should go. Let's take our time.
But you are not against it?
I am against every proceedings which will attempt to stifle the entire process of the Chief Justice. She's doing her work. Why wouldn't they let her do her work? And the next day you hear people are writing to the police that investigate this person, invite this person, do that. No. Why don't we take our time? If at the end of the day the committee finds something wrong, what if these judges, some of them are proven not guilty? What do we do? Their pictures are all over. We have bastardized almost all of them. In fact, we have hung them in the media. And now the public expect one result, remove them. What if it turns out that at least some of them, the evidence, which is the primary evidence that they are relying on, it shows that evidence is impeached? What happens? That's what I'm saying. Let us take our time. The hasty
you have that hope that some of them will be exonerated?
Well, I have gone to watch the tape myself, and I think that basically I have my belief that if time is taken, and I have a lot of confidence in the committee, that they will do their work in a manner that justice will prevail. And I think that, look, the hasty manner with which we are all proceeding should take our time, because I believe strongly that if it was my senior brother Kokubakon, he will be happy. If it was Bakukwati, he will be happy. If it was me, I won't be happy. We all want justice and fairness to prevail in the country. And therefore, my view is that even if it takes, because crime has no expiry date, even if it takes 10 years, justice will prevail. But the hasty manner with which we are going about it, if you are not careful, because procedures are important as substance. And the way we are going about
it. Just in some 30 seconds, tell me, how different is that process from you, a lawyer, knowing that sometimes a criminal process can be going on at the same time a civil process can be going on? Both can go on simultaneously. Well,
that might run maybe for ordinary people like me, you and I. We are ordinary people. For you and I, the
okay, very interesting.
Lay down procedure.
Very interesting. I'm going to hear Kweku's take on this now. But on October 5, there was a press release from the Judicial Secretary, and that said, among other things, that on the advice of the Judicial Council, the Vice President Kwesi Bekwe Emisa Arthur, acting in his capacity as President of the Republic of Ghana on Friday, October 2, 2015, suspended from office with immediate effect 7 out of the 12 justices of the High Court on grounds of stated misbehavior. Their suspension is pursuant to Article 146, Clause 10B of the 1992 Constitution. The justices affected are His Lordship Francis K. Opoku, Kofi Esel-Mensah, John Ajet Nassam, Ernest Obimpe, Kwame Ohene Esel, Justice Ivy Hayward Mills, Gilbert Eisiado. Gilbert Eisiado is represented by Nkrabia Ifadate, we just spoke to a while ago. Their suspension followed the establishment of a prima facie case of stated misbehavior against them by the Honorable Lady Chief Justice, pursuant to Article 1463 of the Constitution. and the setting up of a committee under Article 1464 to investigate the petition. The committee consists of 3 justices of the Superior Court, that is a justice of the Supreme Court who is chairperson, and 2 justices of the Court of Appeal appointed by the Judicial Council, and 2 other persons appointed on the advice of the Council of State, who are neither members of the Council of State, nor members of Parliament, nor lawyers. The Attorney General has been requested to provide a state attorney to assist the committee in its work, whilst a deputy director at the Judicial Service will serve as secretary to the committee. The Chief Justice has decided to suspend the determination of a prima facie case in respect of Justice Mustafa Logo and Justice Paul Derry, who were cited in the petition as a result of the actions instituted by them against her and Tiger Eye PI, which are pending in court. The proceedings against Justice Charles Quist have been deferred on grounds of ill health, following a medical report submitted by his physician on his state of health. Meanwhile, Tiger Eye PI has written to the Chief Justice informing her that the inclusion of Justice Daniel Obing, a justice of the High Court, in the petition for the removal from office was an error. According to Tiger Eye PI, further investigations indicate that the judge they dealt with was rather Emmanuel Opare, a circuit court judge. Our records at the Judicial Service have confirmed that at the time the investigations were conducted by Tiger Eye PI in August 2015, Justice Daniel Obing had been elevated to the High Court and transferred to the Northern Region. This was signed by Justice Alex B. Opokwe Champong, who is the Judicial Secretary. Kuku, what do you say to first Captain Nkrabi Efadate and Gary, who say the process is being rushed?
They are entitled to that judgment. They are. And I've been saying this for a long time, that all those legal actions, initiatives that the judges have instructed their lawyers to undertake are to be expected and to be respected as well. And all that they are doing is within the legal framework. They haven't gone out there with sticks and stones to fight anybody. So these actions are to be expected and respected, I repeat. But a quick one, so that I can get that out of the way. This thing about the Al Jazeera connection, it's not exactly true. I know they are conducting a documentary. They are doing documentary. Portions of what we've seen at the public viewing will obviously be part of the documentary. So no impression should be given as if the full unedited video evidence presented has been given to Al Jazeera. That hasn't happened. Please, let me finish. When you were talking, I was here.
Hold on briefly.
When you were talking, I was here. You created an impression as if the full thing from A to Z has been given. I'm not sure they told you that. So I'm saying there's a documentary that may be shown. As to when, I don't know. But obviously, you will have excerpts which we have already seen here as part of the documentary. That's natural.
Okay.
So that's an extension I wanted to draw. Now, you know, the process is moving smoothly.
Right.
No problems at all. Look at us. We've got to a stage where the committee established by the Chief Justice, as you indicated, had established prima facie evidence, case, isn't it?
That's so.
And on basis of which the Judicial Council has advised the President to suspend 7 of the Superior Court judges. Is that not so?
That's right.
This is a system and a process that is moving smoothly, logically, in accordance with the Constitution. We have passed the stage where there were complaints of entrapment, enticement, provocation, and all the things, some of which my brother has articulated here. We've passed that stage. This process is unfolding, and it's unfolding in accordance with law. And I have said before, look, nobody, I'm not sure, otherwise what would be the need for the processes underway? Nobody has said the video evidence is sacrosanct or the verdict of the public, in this case the court of public opinion, is conclusive. In fact, I have made it clear here that the judges are fortunate that the verdict of the people is not conclusive or proof of guilt. Otherwise, there will be no need for the processes that are underway. So I see how I find it difficult to accept the point that, oh, because of what has happened, okay, the excerpts of the documentaries that we have seen is such that this whole system, the whole thing is a bastardization of the judiciary. Then we might as well say the committee that is sitting, or the one that sat to establish the prima facie case, the Chief Justice herself, the President himself, and all those people involved are all engaged in an act of constitutional lawlessness. I don't think that's what
the repeated use of prima facie, let me just say, the Oxford Dictionary of Law says that prima facie case is a case that has been supported by sufficient evidence for it to be taken as proved in the absence of adequate evidence to the contrary. Prima facie evidence, what does that mean? That evidence that is sufficient to discharge any evidential burden of proof borne by a party, and that may be sufficient to discharge the persuasive burden of proof, blah, blah. A bit of law in there.
But that is very strong.
Yeah.
My unlearned or uneducated mind has been improved, certainly.
A case that has been supported by sufficient evidence for it to be taken as proved in the absence of adequate evidence to the contrary.
That's right. And that committee was presided over by a Supreme Court judge, am I right?
Yes.
Yes. I'm sure they looked at all those things.
No, it's the Chief Justice that made the determination before he referred the case to them.
Yes. Put the two together. It's still very powerful. They are talking law. That's what I'm saying. So you see, we are moving. We're moving step by step. Now, in the course of this unfolding constitutional process, you have the police also coming in.
Right.
You know, the clerks, the other judicial staff,
right,
and the policemen. Do the police have to wait for this constitutional process to unfold to its conclusion before they can focus on them? No. The police has to get involved, invite them. But there's a collateral linkage, implication for the judges. Because you see, they didn't work alone. They didn't do those things. Some of them, there is a linkage. So obviously, criminal investigations by the police targeted at the judicial staff and the other members of other state institutions would, in a way, impact on those judges who are protected by the Constitution the way our brothers are pushing.
Right,
I don't know whether I got my drift.
Well, I get you,
so
but what do you say to John Ndebugri, who refers us to Regulation 30 of the Judicial Service Regulations? It says that if criminal proceedings are instituted against a holder of judicial service post in any court, disciplinary proceedings upon any grounds involved in the criminal charge shall not be taken until the conclusion of the criminal proceedings and the determination of any appeal therefrom.
Yes, invitation to the judicial staff, investigations underway, linkages to the judges. If the judges are invited to come and give their input, is that criminal proceedings yet? Are they on trial?
The judicial staff are also subject to a disciplinary process provided for by the Judicial Service Act.
Yes. So that excludes them from police scrutiny? It doesn't.
Okay.
See, the jurisprudence of this country is being challenged, upon which there will be an improvement. All those who have problems with this are in court fighting. Some have even decided to go to Supreme Court. Those who make noise about the disclosure of the information, they are referring to the Databa ruling. That's an opportunity for them to go and test. I don't see why anybody should be unduly worried at all. They hear lawyers defending the judges themselves in the public domain, as my friend has just done here, making a case. They are out there in the public domain, in the Bugre, Fadate, my brother here.
You don't feel they are compelled to do so?
They are compelled to do what?
In the circumstances, they are compelled
they
to
could
speak.
decide not to talk and go to the committee or the court but they have also chosen to interact, to debate the issues in the public domain. And none of it, nothing being said here is conclusive. That's the point I am making. So I don't see why people are worried.
Interesting. Kwaku, what do you also say about the process, the manner in which the process is unfolding, and the complaints that are coming forward? Don't go ahead with criminal prosecutions yet. Hold on. Then some move forward to say, in fact, you cannot prosecute them, according to the tenor of the Article 1273 that we just read. In fact, I am reliably informed that some of them are going to proceed to the Supreme Court as soon as they are invited by the police to say that they cannot be prosecuted because they have absolute immunity against prosecution.
Well, thank you, Samson. But before I proceed, I just got a text message that I didn't say good morning to my constituents. Good morning to the people of Osei. In particular, Samson, join me in thanking Mr. Michael Tremantin. He's the chief executive of Limac Fabrics. He donated this to me free of charge.
Okay.
So let me say good morning to him. Thank you very much, Mike. And when you need your clothing, I'm sure he will help you.
Don't worry, you get the invoice right after you are done.
Something in respect of this judge's matter, I'm one of those who believe that we should follow due process. I can understand the public anger, and video is video. Nobody created human beings the way we are. When you see video evidence, your emotions will respond to it. And the response of the public has been anger. And therefore, there's a temptation that we'll begin to do things to satisfy public anger. So I share the view that we should begin to think carefully and to see whether some of the things we're doing is not a matter of responding to public anger. But having said that, I think so far, so good. I don't see the process as rushed, and I'm not too sure that so far we have been so unfair to the judges. When Kuku Bakon was making the point that if it wasn't for due process, it was the revolution, perhaps it would be worse. And we should be grateful to the system we have that we're taking time to go through this. You mean
people would have been taken to firing squad?
Oh, of course. You can easily imagine, because the anger I see out there, and sometimes even when you're commenting that let's follow due process, people are angry with you because people just think what they can see with their eyes isn't proper. I side in part with what my brother said. We should allow due process to flow. But so far, that is what has happened. I cannot find any rush. When the matter went to the court, there was a pause in the committee's work. The court determined the issues, and so far it's going well. I, like many others, wish the processes would be faster, but that is what the law says we should do. I think we should do that. The concurrent running of a civil cause of action and some criminal cause of action, well, you are lawyers and you understand that better. But when you read from the Constitution, and it says in the exercise of judicial power.
Yes.
And I asked, what was done, especially where it was done in the homes, and was that the exercise of judicial power? And you put the question, I wouldn't want to belabor it. I was imagining if a judge raped my little daughter, and this judge cannot be picked up by the police, I'll be very worried. And if anybody is going to go to the court on this matter, we'll all be paying attention to understand what the position of the law is, so we'll be advised. But if you left it to me, my layman's mind, what is happening by what is being supervised by the Chief Justice?
Kwaku, on the bit about the sort of privileged treatment that they are receiving, that you talk about, what happens to members of parliament? Don't we know? Criminal processes or civil processes, you are unable to be taken through them when you are in the business of parliament. You have immunity against criminal and civil process. When you are in the business of parliament, you can't be arrested. The processes of court cannot be served on you. So why should the judges get any different?
with the explicit permission of the speaker,
yeah,
you can be subjected to criminal investigation.
Exactly. That's the point I was going to make. But also, when in the exercise of your duties, in the exercise, you see, that point is important, and there's a sense in which that covers everybody. If in the exercise of your legitimate duties you offend, then those processes could be activated. But when you do just because you are, say, a member of parliament or a judge, and you do what, for the purpose of what I'm saying, you do what is wrong, and we're saying that we cannot activate those criminal processes against you because you are a judge. I'm not too sure if that is what the Constitution says. If it is not in the exercise of judicial power, it's hard for me to appreciate why those actions cannot be brought against you, unless the Constitution and the law could be read to mean that if you are a judge, then no matter what you do, criminal proceedings cannot be brought against you unless your chief justice does so and so and so. Or if you are a member of parliament, then merely by being a member of parliament or a judge, criminal processes cannot be triggered against you. If that is the reading of the law, then you'll be right. But the point there that in the exercise of your judicial power is an important point.
What if their lawyers told you that they took these monies, allegedly, to influence the exercise of their judicial power?
My understanding would be being in court and a judge says something or gives a ruling that has an unjust effect on some parties, then that wrong would have been committed in the exercise of that judge's judicial power. Or if on the floor of parliament I am debating a matter and I make statements that, for instance, are libelous, or that if in the course of my work I offend, the law is saying that in order that the person could do the work he or she is doing for the state, we would not want the person to be treated as though the person set off to commit a wrong. That's how I read these legal provisions.
Okay.
But to read that kind of law to mean that when you're a judge or when you're a member of parliament, then we cannot initiate criminal actions against you unless your heads have done some things. It's something that doesn't sit with my understanding of the law. But as I said, I am only a layman. If somebody is going to go to court to test these things, it will be helpful. But to conclude, Samson, my own thoughts in respect of all this is, perhaps it's a disappointment, is that we have focused so much on wrongs that we think have been committed by individuals. And the passion has been, let's punish them. And the corrupt judges. What I think we are not doing, and which we ought to be doing, is to focus more of the discussions also on those institutional changes that have to be made to ensure that these things don't happen going forward. I have no doubt in my mind that we could, the judges could be indicted, they will be removed from the bench, the police may successfully bring prosecutions against them, they could be jailed. Unless things change in the judiciary, people will always find a way of committing these particular wrongs. After all, armed robbers are caught and jailed and shot, and others still commit armed robbery. So we also should be discussing what are the institutional changes we can make? What made it possible? Is it the supervision of rulings by these judges? What is it that we have not been doing? And we need to hear from the Chief Justice more. I remember when this matter came up and the call was made that the Chief Justice ought to resign. Of course, I didn't share that sentiment, but we cannot take it away from those who made that point, that in the end, the Chief Justice oversees this institution. Now, if these wrongs happen, of course, when we were going to commit the wrongs, they did not inform her. But they happen under her supervision. So, whilst I would not support her removal or a call for her resignation, I think she has a burden also to be telling the public as a way of building whatever confidence has been lost. What institutional lapses made some of these things so pervasive in the judiciary? And then all of us can join in that discussion. Lastly, something quickly, 1 minute. Lastly, as a nation, can we not make this kind of integrity testing? You know, the analysis approach, I call that integrity testing. Can we not mainstream it? Can we not make it one of the ways to check corruption, not just in the judiciary? I understand some has been done on Parliament and on the executive. Can we not make integrity testing one of the mainstream approaches to fighting wrongs in the public sector and even in the private sector?
That's an interesting question. Thank you very much. Now, you have been asking what the CJ has been saying about all of these things. She's been speaking a lot about this over the weeks and the months since this issue broke. Just yesterday, at the inauguration of the new High Court complex here in Accra, she had something to say about this situation. Let's hear her briefly, and then I'll come to Gary.
Over the last couple of weeks, I have had the unpleasant duty of speaking to a subject that is hardly comforting to the ears of all true patriots. From documentaries shown to the public to commentary on the subject, a subject that has led a few people to ask me, how did we arrive here? The discussions have been endless, and understandably, the judgment of an angry nation unrelenting. And in the mood of the time, the good have been lumped together with the bad. We have been collectively condemned, with no one being spared. In my respectful view, on account of the critical role this branch of government, which is a key pillar to give good governance, is expected to play as watchdogs of law and order. It is true that over time, the warped conception of the role of a judge by a few among us has marred the beauty of what the judiciary stands for in this great nation. The deeds of these few have dented, and I've chosen my words carefully, have dented but have not destroyed public trust and confidence in our work.
Well, let's hear what you have to say in reaction to what the Chief Justice just said, that it is dented but not destroyed public trust and confidence in the judiciary. Let me have your text messages. I'll be reading them shortly. Let's hear also what the President, John Dramani Mahama, had to say about this. He spoke far away earlier outside of Ghana, suggesting and making it very clear that prosecutions were to happen. And indeed, they began, process to prosecute began. Let's hear President Mahama also at yesterday's inauguration of the new complex for high courts.
The Anas petition presents us for the first time with accusations against specific persons and accompanying evidence to back his claim. The Anas video has provoked all kinds of salacious conversations and discussions, both in private and the media, and our judges, regrettably, have become the butt of jokes in chop bars and restaurants. But ladies and gentlemen, this malaise affects all segments of our society. The executive, the legislature, the media, the clergy, traditional rulers, educational institutions, health facilities, and indeed the list is endless. I'm proud of the response of Her Ladyship, the Chief Justice, and the Judicial Council. The promptness of response and action taken indicates that our systems are working. The Judicial Council, the Chief Justice, and my office have acted swiftly to protect the institution of justice. The referral by the Chief Justice of the petition to my office and the prompt approval for investigations to be conducted into the conduct of the judges cited in the petition gives me great confidence that our constitutional system is working.
Now, let's hear what the CID has been saying about their attempt to commence processes towards prosecution.
We are investigating the announced tape involving the judges, as you have already indicated, the 13 High Court judges and the 21 Circuit Court and Magistrate judges, and then additionally about 100 staff, members of staff of the Judicial Service. So we have launched investigation into this announced tape. And as I speak to you, the 8 policemen involved are on police inquiry bail. We have their statements. We started with them because they are our own. It was easy to get them. So we started with them. And as I speak to you, they are on bail. We have commenced investigation. We have written to the judges. They have responded positively. And as I speak to you, this week, 2 of them are reporting to us. And then from next week, the rest will follow suit. So the rest will follow from next week. So we have already started investigation into the issue.
And that's Joseph Benefo Dakwa of the CID, and he has been briefing the press about the process so far. Now, quickly, Gary, some are asking really, the police have started with judges who are already going through the process. They thought that what the police would have done would have been to rather look for those judges who are on retirement and will not be going through the disciplinary process.
Yeah, something I think I should agree with you on that point, because you see, for a retired judge, he doesn't have to go through all this laborious process. So reasonably, if there was even anything about criminality we are talking about here, I think it ought to have started from them rather, to invite them, to question them, to find out whether indeed any bribe were offered to them, who offered the bribes, whether or not offered the bribes. And don't forget that whoever is offering the bribe to is also guilty. It's also guilty. Who offered the bribe, if in fact the bribe was offered. And then two, if the bribe were even offered at all. Wow. Offered at all. They did in fact influence the cases that were before them. It's a very critical point that I want to see. Because for instance, if you say that you gave me X amount of money to do Y amount of job for you, and it turns out that the work has not even been done, you have to question it. Now, if it shows that yes, you did not even give me any money, or the video footage that you are relying on did not show that you're even giving me any money, you have to question the process. So basically, I think that this whole Anas saga and this whole thing that's going on, I have a difficulty with it. And for the fact that the gentleman has shown Ghana to the international media, that's my concern. That's my concern. He has shown Ghana to Al Jazeera.
Okay, let me get this briefly from you. Are you going to take the step that some intimates they are likely to take if their clients are invited by the police to go to the Supreme Court and to seek to challenge this process? Let me welcome Haruna Idrisu, the Minister responsible for Labour and Employment. Thank you very much for joining us.
Thank you.
Thank you indeed. So, yes.
Something you know that lawyer does not act in vacuum. You act on instruction. So basically, you cannot sit here and then.
But more importantly, you are so certain that your client, Isel Mensah, is not guilty of anything.
Well, the video footage suggests that. It suggests that. But we cannot argue our matter on the television.
So how come you are not also in court challenging these processes, but you are submitting to only the judicial inquiry?
You see something.
As in the...
You see something.
Investigations.
If you believe in... Sometimes you need to evaluate the things and see which action to take. I think that he thought this is the way to go, and he has submitted into the process. So that is a decision that he has taken. So it's not for me to question a decision of a very senior person. So he wants to go through the process.
You will also be seeking that Anas will be unmasked whilst he's cross-examined?
But something I do not understand, that for a person who claims to have worked in somebody's premises when he was not wearing any mask, will now go to a judicial committee and say that I want to mask myself. How do we identify who the person sitting there? The person's demeanor, the person's truthfulness. How do we determine all those things? You come and sit here and then you are masked. You can't even look at your face and determine the propriety of what you are saying. Now, I do not understand why, if for instance, you believe in your story and you believe in the integrity of your story.
The committee is headed, those of the lower courts, the committee is headed by justices that you can say know what they are about. They have thrown out this objection as irrelevant.
Well,
so you are left with cross-examining him whilst he's hooded.
Well, we'll get there.
You get there. Kweku, briefly.
You know, I don't know, you are the lawyers, whether the identity of whistleblowers are disclosed to those whom they blew the whistle against. I don't know about that. When we get to that level, the legal regime in terms of the whistleblowers, they will be looked at. But please, the bribe giver as well as the receiver are guilty. Classic. That's what the law says. It's classic. In these particular circumstances, let's double check. Let's interrogate the scenario. Okay, the police could come ahead, arrest Anas, arrest the judges, because all of you are guilty. You do criminal investigations. You have to be determining the motive of each. So in this case, Anas, the bribe giver, what was his motive? What was he seeking to do? Now, the judge who took the bribe, who indeed has this whole so-called high moral character and proving integrity as his insurance base, and who must deliver justice according to law. Now, he took the money for what purpose? He engaged in some ex parte communication with the bribe giver over an issue before him. Is it allowed? Ethically, based on their code. So you see, it is not just putting out a classic theory about the bribe giver and the bribe taker are both guilty, but it will be subjected to critical scrutiny, looking at all the ingredients involved before prosecution and even judgment is delivered. I think we have to be clear on these matters, okay?
Thank you very much. Now let's hear briefly from the Labour Minister, who is also a lawyer by training, his views on these matters. I haven't heard him say any word about it so far. What do you make of the process that is going on so far?
Samson, I rather thank you for the opportunity and for the opportunity to join your other resource persons. I rather would have kept on to some golden silence as this matter evolved and we all study the jurisprudence on the development of matters which affect a key governance institution, which is the judiciary. Apart from protecting our civil liberties and rights, is the adjudicator, and confidence in it is at all times expected to be at its moral high. I think that the expose of Anas raises fundamental issues of some worrying trends, that the perception of judicial corruption and the reality of it. Suffice it to say that all this have to be proven in law beyond reasonable doubt. I think that my take on it, one, is that as the President rightly pointed out at the inauguration of that beautiful edifice, and undoubtedly one of the highest investment in terms of judicial infrastructure, I trust and pray that we would replicate same in the other regions. I know what you lawyers and judges go through. I watch my own Tamale High Court, and anytime I drive past it, it does not give me an encouragement of a facility as important as what is hosting both the appeal court and the High Court in Tamale. So in terms of judicial infrastructure, but in terms of the Anas thing, I think having listened to your resource persons and your good self with background in the law, I just like to emphasize one thing, that judges are not angels. Ministers are not angels. Members of parliament are not angels. Media practitioners are not angels. I'm playing another aspect of what President Mahama said, that corruption in Ghana is systematic and pervasive. And we need a new national consciousness and a collective national effort to reduce the canker of corruption. But specific to the judiciary, it is even more worrying when the institution which is responsible to ensure justice itself is compromised. But two critical things we need to do. One, to accept that within the judiciary, there are men with high-level integrity and uncompromising morals. Okay. And at all times, we must respect that. I thought that I heard Her Ladyship, the Chief Justice, Mrs. Theodora, make this elucidation yesterday. And that's very significant, that we are condemning the institution of the judiciary and every judge in Ghana as if every other judge was corrupt. I have difficulty accepting that particular position, which is also backed by evidential research evidence of ANAS, that there are persons who are upholding the calling of the duty of a judge in terms of that. The second important issue is judges are entitled like any other Ghanaian or all other Ghanaians to the benefits conferred under the 1992 Constitution, which includes the benefits to a fair trial, the benefits to be heard, and the benefits of the law in terms of the right to defense. And I think that we should do that. To that extent, I couldn't agree more with both President Mahama and the Chief Justice when they both said that the responsiveness of the judicial system, I maybe want to know, and maybe we should go back to Obama, let your institutions work, was a remark President Obama made when he came to Ghana. I think that both the Chief Justice, Her Ladyship, the Chief Justice, and the President were right when they said that this is a litmus test for the institution of the judiciary and for the functional relationship between the executive and the judiciary. And I dare add that none of these decisions have been taken without conferring and consultation between the two important arms of government. But I think we must recognize and respect the right of every judge to a fair trial, to the protection of the law until otherwise declared by provisions of other laws. Now on ANAS in person, undoubtedly, I think that his expose would be a turning point in our quest to fight corruption. I did some little study of corruption sometime in school, and we say that what corruption hates is sunshine. It thrives only in darkness. Right. And what ANAS is doing is to sunshine the ills of it, which warrants that we would be able to deal with it swiftly and promptly as we have done so far. And I think that Her Ladyship, the Chief Justice, deserves our commendation for showing leadership in terms of the handling of this matter and consultation in getting some of the judges suspended in accordance with provisions of the Constitution and others. But I think that there will be more of it that will be revealed to the Ghanaian public as we go along. I do agree with Kweku that you don't look at the Constitution standing alone. You look at it in terms of other promulgations, and you have the Whistleblower Act, which we accordingly amended in Parliament, which does give some protection. We, in fact, have passed other new legislation as part of our quest to fight this national thing. And to the very last speaker, I think also, like it or not, what has happened can hurt Ghana's standing in terms of investor confidence in our institutions, and particularly in the judiciary. On the merits of it, I'm sure I'll have some other opportunity as I'm studying it carefully myself, in order that one can make an informed position on it. But I think that so far, the handling of it by Her Ladyship, the Chief Justice, the Judicial Council, and the judicial system, and the support given by the President as Executive President is commendable. And I think that we ought to follow the process through.
Thank you very much. Now, let's quickly go to the phone lines and speak to Egbert Fable Jr., who is a private legal practitioner and has been following the discussion. He wants to make a very critical point about the question of removing, unmasking ANAS in the process of cross-examination in the process. Thank you very much, Egbert, for joining us.
Thank you very much.
Why should he not be unmasked?
No, Samson, I think that as lawyers, we all know something. Identification is very important in any trial, in any hearing. And I would just want to place on record that I've had occasion as defense attorney when Anas was a prosecution witness in 2 separate trials, one before the circuit court here in Accra and another before the High Court here in Accra, where Anas was a prosecution for a witness for the prosecution. All that the judges did in those 2 cases was to clear the courts of members of the public. And then Anas was brought in through a back door, his face showing. He came and mounted the and he gave his evidence. And I as defense counsel cross-examined him in the matter before the circuit court. In another matter before the High Court, the same thing took place, and he was cross-examined. His face was showing. As I mentioned, the law who did that other matter with me. So when the posturing is given by the committee that Anas has to come to the committee sometimes in triplicate and his face covered, and I think that is not to be decided. What would be the basis of the judicial, or if you like, direction by the committee that Anas should come there, could there? I represent a number of court clerks. Only on Thursday, we appeared before the committee and were shown the video, I think for the 3rd time, in respect of each of my clients. You know what happened? When the videos that were shown, something, the person who did the recording, it's not in the video. It's not seen in the video. It's not Anas. The person is an employee of Tiger Eye. Now, if you want me to do a good job, defense counsel, you ought to bring the person. The person came to the judge's homes, you know, in plain face, was not who the judge saw the person they were dealing with. So why is it that when it matters most, that cross-examination must take place or the person must come and give evidence, he's covered? So that identity becomes an issue.
But the law does not also say the law does not also say it is wrong for the identity of the person to be covered. Does it say so?
Something. The law does not say so, but there is something called common sense, with due respect. If you have come to, if you like, engage with me, plain face, and have seen your face, why is it that when it matters most, the system wants to say that no, even though he did his plain face, at this level, we want to cover his face? Because you know what? The committee is even sitting in camera. So all that will mean is that it is the lawyers and, if you like, the accused persons in court, the judges or the court clerks, who have the opportunity of seeing Anas, plain face during the proceedings. Beyond that, nobody else can see him.
Right, Egbert.
So equality is equity.
Right.
And I just want to say this. There are instances in courts, judicial courts, where Anas has testified places. The only thing that happened was that the court was cleared of members of the public.
Egbert, yes, I've gone through a similar process before, and the whole place was cleared, and then I just entered with Manasseh Azore, and he gave his testimony, and we went out just before the lawyers and the people involved. But the question being asked now is that what difference will it make having the person's face shown? Will it change the facts? The facts that the video is showing you a man receiving money, a man receiving goods, and promising to do certain things and actually doing them?
It is obvious that a human being is the one who did the recording. Why is it that when it matters most, when that recording is supposed to be put to strict proof and strict test under our laws of evidence in particular, the face of that person doesn't want to go? You know what? Some of the tapes that I have watched, different names have been used. One person goes to Judge A's house, uses a different name, goes to another, uses a different name. Now, is it not up to us to then see, for the judge to identify whether this is the character who came to my house?
Okay.
Otherwise, they can go and bring anybody from anywhere to come and pose as the person who came there.
Do you also appreciate the argument that this is a very special circumstance and ought to be treated as such?
How special is this?
Because about 10% of the judges of the country involved,
where agents of the state act as agents provocateurs. Those agents of the state are shown in open court for them to be cross-examined. And there's nothing more serious than treason. Like that, if we are alleging corruption and somebody has done work which everybody is applauding, no problem.
Okay.
Let that work be subject to the strictures of evidence giving and evidence taking, even in the case of minors, young offenders.
Before you go, just maybe 30 seconds before you go. So in the end, you are being compelled to go through the process without him, removing the mask. what does that mean? What effect will that have on the process eventually?
Well, but when it gets to that point, we will insist on the right thing being done, because I don't think that Anas has anything to hide.
Okay.
I don't think that Anas has anything to hide,
okay.
so that the committee should not seek
okay.
to also hide Anas.
Egbert, thank you.
He's known.
Thank you very much. Thank you very much, Egbert. We're supposed to end it here, but yeah, just...
I've been having this running debate with Egbert all this time.
Okay.
But you see, something struck me about the point he made, that the one who went to the judge didn't go hooded.
Yes.
Would the judge have taken money from a hooded person?
Okay, interesting.
And see, the key point is this, are the judges seen in the video taking money from the one who is not seen? Are they engaged in party communication over a case before them or not? These are more substantive than seeking to unmask analysis.
And Kweku refers to ex-party communications, because this is prohibited by their own code of conduct, and the Chief Justice made a stress of that. And you also wanted a quick one. Yeah. Yes, I'll give you the last.
Haruna made a point about this thing having the potential to damage our image to the investor community. But it reinforces the earlier point I made, and I just want to make it again. Except we see perhaps correspondingly high publicity for the institutional reforms to fix this. I mean, let's face it, we are all not angels. We all have our little ways and all that. Okay. So it is the institutional changes that would guarantee us the right things going forward, rather than just zeroing in on the judges and asking for their blood.
Okay, thank you very much. In fact, the president was asked a question about this when he was outside of this country, so it's already out there. And yes, so I'll give you the very last laugh quickly.
Something who made mention of ex-party communication.
Prohibited by the code of conduct.
Yes, I've been contemplating. Was Anas a party in the case before the judge?
He went there as a party in the case.
And was he in fact a party in the case before the judge?
Well, they made the representation, and the judge encouraged the conversation.
It's something that I have been reflecting about. That and I think that all these are matters which the committee really go into it. But I believe strongly that absolute fairness and reasonableness entails that if you are a petitioner, come in clean hands. Behold yourself. Let's see who you are. Let's check your demeanor. Let's ask you questions. Because you see, the sanctions for this particular thing is very huge. Dismissal.
Yes.
Or even criminal sanctions. And therefore, it is important.
Thank you very much. Thank you very much. And Gary Nimako takes leave of us whilst we take a break right now. When we return, I'll read some of your messages and we'll proceed on to the next.
This is a rude intervention. I wanted to know his client, Justice. Is he one of those 7 suspended?
Yes, he is.
Oh, so he didn't pass that particular test?
Of what?
The prima facie. He didn't pass it.
Kweku, you don't know what he's communicating to you. You don't get it, do you? All right, we'll take a break. We'll be right back. You're welcome back. This is Newsfile, your most authoritative news analysis show. And before I do your text messages, very disturbing news coming to us is that one of the gentlemen who work for Anas Armia, Anas's Tiger IPI, has been taken hostage, has been picked up by somebody, not security officials, has been picked up in Tamale. And it does appear that it is in connection with the ongoing process involving some of the judges. And this guy is called Ishmael Hussein. He's been taken hostage by someone in Tamale. The police should get into action, and let's see if you can rescue this gentleman, because obviously they are doing work for this country. And that's just by way of information for now. Subsequently, we may be bringing you the details about the individuals who are alleged to be involved in seeking to do this sort of thing. Thank you very much. Ishmael Hussein, that is his name, the police in Tamale particularly, and other security officers. That's for your attention. Now, some of your messages here. Sofo Yamusa in Kumbungu says, it will be a big blow and dark days on the entire nation if Anas's recent expose is thrown out based on technicalities. Indeed, if the corruption scandal is not handled properly, Ghanaians will eventually lose confidence in our justice system. The implication of this will be disastrous.
I'm told the place is known as Filling Point. Maybe
Filling Point in Tamale.
Yeah.
Filling Point in Tamale.
Yes.
Filling Point in Tamale. The information I was putting out earlier about one of Tiger IPI's men, Ishmael Hussein, we understand he's been taken at a place in Tamale known as Filling Point. The security should get into action and rescue him. If anybody has an issue with him, they should take it through due process. Dixon Entry says, are the lawyers of the judges saying that the judges by virtue of their protected immunity, a judge can take a gun and shoot to kill another to death, and he cannot be arrested until the slow administrative processes and subsequent procedures are completed? Can you imagine if a judge shot the president to death and we say he should go home to sleep in his bed because he has immunity from arrest? That is to stretch the well-intended constitutional provision to the absurd level. Musa Abatoa in Kumasi says, I find it difficult that some lawyers behave towards this Anas bribery scandal. What evidence do they want to see to understand this is clearly a distortion of money? If it were in UK, these judges could have been behind bars long ago. You need to take it slow. Maybe in the UK, they enjoy absolute immunity. Go check. Bonti Benjamin in Achime Buakwa says, no use in the name of indemnity can, no use in the name of indemnity can save the corrupt justices, looking at how the CJ is poised to redeem the image of the judiciary. Oliver Bamba in Salaga says, did I hear Gary say both the giver and the receiver are guilty? One thing Gary should know is that in this instance, the giver has nothing to gain out of the decision being taken by the receiver. Washington in Wasa Wantram says, I would like to place on record and emphasize saying that Anas does not need to be unmasked before the truth could be told. The lawyers must sharpen their arsenals to defend their clients before the committee rather than hanging on to this straw of unmasking Anas. Truth be told, the judiciary has lost its integrity. Okay, thank you for those messages that you sent in.